but the law doesn't forget. And if you run into a situation where there's something catastrophic that happens in your life and you go, you know what, I'm just going to go out for a drink. You get pulled over. We need you to remember this for the rest of your life.
This courtroom clip shows the tension courts live with every DWI. How to punish, how to rehabilitate, and how to make consequences land so they change behavior. Right here, the judge is wrestling with a common problem, converting what could be a mandatory short jail stint into alternative terms that still get someone's attention without automatically locking them up. You'll hear talk of fees, interlocks, ankle monitors, portable scram devices, license suspensions, and the real pocketbook pain judges think will stick in a defendant's memory. Stay with US. We'll unpack why judges mix cash penalties and devices to deter repeat drinking and driving, and whether that mix actually helps people stop driving drunk. Would you prefer a big financial hit, monitoring tech, or guaranteed jail time to stop repeated offenses? Drop your hot take.
For the rest of your life. Somehow we need to get that to happen. And I'm hoping that this is it. We can put on a longer payment plan if needed, Joaquin. So, you know,
That would be appreciated, Judge.
I mean, we can do 3 years. We can do as much as we want, but I wanted to get her attention.
Yes,
right?
sir. And I also wanted to ask the court about since now she's going on probation, can she get the scram and the?
Absolutely. But first she needs the, now I am going to suspend your license because it's a second offense. I'm going to suspend it for a year. You will need a portable device. Once you get that portable device, we will take the ankle monitor off. So she needs a guardian interlock
Yes, sir.
for the life of
already
this
have it.
probation.
Yes, sir.
You have a where?
An interlock?
In your car?
Yes, sir.
Okay, well, I'm going to end up suspending it now. So once you get a portable device, I'll take the thing off your ankle.
Okay, so, why is the court suspending her license, Your Honor?
Because it's a DWI second.
Really, she's pleading to a first?
And it gets suspended regardless.
The ALR.
It's a DWI. She's doing a multiple DWI education class. DPS is going to suspend her license regardless.
So you want her to get the interlock, the portable, then she can get the scram
I
removed?
mean, I get you on the ALR hearing, but the way DPS works is, from my experience, when you do multiple DWI education classes, they end up suspending your license regardless. So you need to be on the lookout for that. So,
Well,
you know,
Your Honor, we'll be filing an occupational petition here soon. We're going to ask the court to allow her to drive. She needs to get a job, Your Honor.
I'm a data analyst, but I recently got laid off in January. So I'm trying to find a job, but it's making it a little bit difficult with the ankle monitors to.
all right, I won't suspend the license then.
Thank you, Judge.
Thank you very much, sir.
But before you start driving, can you run the license right now, please?
Yes, Judge.
Just to make sure.
I see as of
Before
now.
you start, like I said, because this is now going to reflect another conviction and you're going to be doing a subsequent education class, you need to be on the lookout. You need to make sure that DPS has your correct, address on file because they're going to send you notice. They should send you notice if they do about the suspension.
I see it's not eligible right now.
Your Honor, I have the order that we want here. DPS, the website is notoriously late for updating but.
Does it show?
The only most recent enforcement action that says canceled interlock required as of.
Okay, since she probably didn't send the $10 fee is probably what I'm thinking,
Yes, sir.
So DPS should have sent you notice that you have to pay a $10 fee to get a special license that you carry on you because of the interlock requirement. If you don't pay that $10 fee, they end up suspending your license. You're not allowed to drive, man. Your license is now currently suspended.
We'll
So
get it done, Judge.
Okay.
don't drive right now. If you drove here, you can't drive home. It's suspended.
Okay.
If you drive, you're in violation of this probation as of today. So you need to call DPS to figure out what you need to do to get your license reinstated. So don't drive.
Okay.
So what are the total costs now? So the total cost of this is $5,010. I will give you as much time as you need to pay, like I said. But if you start drinking, You pick up a new case. I'm just going to go bonkers. I want you to know now. Don't. Hopefully this has been enough to get your attention that we mean business. Every day someone dies from a DWI in our county. It's not fair. All we're asking, just don't kill anyone. How do you plead to this offense? Guilty or not guilty?
Guilty.
I'm going to find you guilty, sentence you with agreement. You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this, there's no turning back. You can never undo this. Now, like I said, you do something to violate this, a warrant will issue. You will go into custody. You're facing up to a year in jail. If you ever have any issues, come back. We can talk about it. We can work through it. But the worst possible thing you can also do is just take off and abscond. That's a guaranteed warrant. Okay? All right. Good luck, man. Thanks.
Thank you.
Okay.
Morgan?
Okay.
I was just appointed to her
Good morning, Miss Morgan.
Good morning.
Did you need anything? Did you want anything?
to see if we can get a PR bond for Miss Morgan. I spoke with her and so she is living in Houston. She lives with her children. And
You don't show up. You never show up. I mean, you never show up.
Yeah, they gave me a bus, my bus pass and everything, so I know I could, what time to be on and what court to actually go to.
We've given you 3 different PR bonds and you've never once appeared, ever. The only time we see you is when you get arrested.
Yeah, this time was my mama gonna take off and everything, so it's different this time.
Why could that not happen the first
Because,
2 times?
because of her job, but this time she said she could take off. Instead of me catching the bus and getting lost, she could take off.
she does have a family that lives here, Your Honor.
I'm sorry, Miss Morgan, but you just don't appear. You never appear. I've given you PR bond after PR bond. You know, not only that, you pick up one case. We ask you, hey, come back to court, just be good. And you pick up yet another case. And on that case, you've flaked out on us 3 times as well. So it's not just been 3 times, it's been more than 3 times where we've given you chance after chance after chance after chance after chance, and you blow us off. If I give you a PR bond now, I don't think you're going to show.
I'll show.
You promised that 4 other times.
I made it down here though, to be honest, I did.
Yeah, I'm sorry, man. I just don't. We've given you like 4 different chances for you to appear, and you've never done it once. You've got 2 open cases now. I don't think you're going to show. I really don't. I'm sorry, Hugh, but really.
What I'll do is I'll get a like a short reset.
I'm happy to give you a bond reduction if you want a bond reduction. And your bonds, I have your bonds now set at 7503 on each of your cases because you just don't show. I'm happy to give you a very, very reduced bond, but I'm telling you, I know if we give you a PR bond, because history tells us you're just not going to show.
No, history doesn't say that because you don't know what's going on in my history. You're just going by what you see on your information. But in reality, if you had a camera set till the time you let me go from downtown all the way up until now, you'll be apologizing. The whole court would, to be honest. I don't know if you know what I went through.
I get it. I do. We all have circumstances. I waive everybody's appearance so they don't even have to show up to court. All I ask is for you to stay in touch with your lawyer. That's all I ask.
I have his card right now. I never had a lawyer card. I never had a lawyer. Only Mr. Bonnie.
Have you been appointed on this?
I was just appointed today, Judge. So I don't believe she had an attorney previously or so.
Where are you living?
At 124 East Golf.
No. I don't want the address. Who with?
Huh?
Who with?
My kids. My mom have my kids right now. I have 7. I believe my one of my kids
Pause
are in
here.
court.
The bench is shifting from moralizing to mechanics. How do we operationally deter someone from repeating DWI behavior? The court's toolbox is twofold. 1, financial pain. fines, supervisory fees, and special charges that hit a bank account and an insurer premium for years. And 2, technical restraints, interlocks, portable scrams, and ankle monitors that physically limit the ability to drive while impaired or to avoid alcohol without immediate detection. Legally, those measures serve different functions. Fines and fees aim to alter future cost/benefit calculations, make drinking and driving expensive enough to discourage it. Interlocks and scrams remove the opportunity or detect violations in real time, creating immediate consequences that don't rely on luck or a future arrest. But there are equity problems. A lot of defendants can't afford the interlock monthly fees or the $10 DPS administrative items, and ankle monitors or GPS can interfere with employment. Practically, judges try to calibrate, waive or extend payments to preserve employment, or impose longer monitoring when the risk of harm is high. For the viewer, think about this trade-off. Is a device that prevents driving better social policy than jailing someone who can't pay fines? Which reduces repeat offenses in your view?
One of my kids are in court right now in Houston, but I have 7 kids.
So you're living with who? You say your mother?
With my kids.
Find out if she has a stable place to go to. See if she has a place to go to, like there's a stable home, and then maybe I'll consider it and I'll put a monitor on your ankle.
Okay.
But I'm not going to let you out just to the street. That's not going to happen. But if I know that you have a stable place to stay, like your mom or a relative, someone that's willing to take you in,
Yes.
but into the street, it's not going to happen because I know what's going to happen if I let you out to the street.
Okay.
So call, see what you can do, and then we'll go from there.
Okay.
Okay, this is you, Ray, right?
Good morning, Judge. Yes, sir.
Hey, good morning. You are Stephen Chavez.
Yes, sir.
Mr. Chavez, you're charged with driving while intoxicated, second offense. Wait, Stephen, we've got 2 Chavezes, right? Okay, so you're charged with driving while intoxicated, second offense. This is a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. So you know you're not here alone. Your lawyer is here with you, but he's on Zoom.
Yes, sir.
Okay?
Yes, Judge. On March 6, 2025, the officer received a call from an officer who was finishing a separate unrelated call and observed a vehicle stop 150 feet from the intersection for an unknown reason for a short period of time, then accelerate unnecessarily quickly before coming to a stop at the intersection. The vehicle was stopped straddling the dividing line between lanes and stopped past the designated stopping point. The vehicle remained stationary through several light cycles, and officers approached the vehicle. The officer observed the defendant, the driver and sole occupant, reclined in the driver's seat unconscious while the vehicle was running and in drive. The officers woke up the defendant, and the defendant appeared confused and took his foot off the brake, causing the vehicle to collide with the marked patrol vehicle placed in front of the vehicle. The officer observed the defendant to have red bloodshot eyes, slurred speech, and an odor of an alcoholic beverage emanating from his person. The defendant was transported to Pasadena jail for further investigation and denied drinking alcohol. Standard field sobriety tests were administered, HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and consented to provide breath. The results were 0.183 and 0.180.
All right. Can you run his NCIC? How many DWIs does he have and whether he has a license as well?
One prior DWI out of Minnesota, and his license is eligible.
Okay. Mr. Chavez, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you.
Yes, sir.
If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail. No more PR bonds.
Yes, sir.
I'm now placing a restriction also on your license that you're not to drive any vehicle that doesn't have a guardian interlock on it. If you're caught driving a vehicle that doesn't have an interlock, likewise, you will go to jail. We send notice to DPS so that every single officer in this state knows that if you get pulled over, you're supposed to have an interlock. So if you get pulled over, an officer sees that you don't have an interlock, you will go to jail.
Yes, sir.
You understand? Now, you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Davila, and he'll tell you if and when you have to come back to court. If he tells me that he can't get hold of you because you're playing games, likewise, I will issue a warrant for your arrest.
Yes, sir.
All I want is my city protected. Don't pick up any new cases. Don't become a danger to my city. Do you understand?
Yes, sir.
For now, I'll have you go sign a reset with Victoria. You'll get with Felicia for your bond conditions, and after that, you're free to go.
May 13th through the 15th.
May 13th through the 15th, Ray.
Let's see. I think May 15th works, Judge.
Okay, it's yours.
Thank you, Your Honor.
Good morning.
Morning.
How's jail? How's jail? Shh.
That's all right.
Like,
No, it's not a place to be, but it's all right.
why do we have jails? Why do we have jails? Why do we have them?
To sit people down, to think about what they have already done.
For people who cannot conform to society, because we got people who are just complete chaos.
Mhm.
How long you been in now? Through a month? 2 months?
Yeah, something like that.
Who do you have in your life? Do you have anyone that's willing to watch over you? Mom, dad, anyone? Who do you have?
I got my little brother Pops. You feel me? My aunt. I got in contact with him. What's his name? While I was in there incarcerated just recently. You feel me? So yeah, I got them.
You know, your lawyer and the state have been working a deal to basically get you out, but you scare me. I mean, you think it's funny. It's not, man.
It's
You
not
know,
that. I'm trying to just listen to everything you say though.
life as a black man in today's society is hard enough as it is. You know, it really, really is. You know, you already under the gun. And with all the shisa that you're picking up now, being on felony probation, you picked up these 5 cases now with us. You're literally killing your chances of ever doing something worthwhile in this life, because you're either going to end up dead or with a 25-year sentence. As a statistic, we have enough statistics, Mr. McGee. You know, how many times has he mucked up or had a DVR or a motion filed upstairs?
One motion, but he failed to report in November, December 16th, December 31st, and January 13th. He also failed to complete IOP, thinking for a change in the law violation.
Does he have any felony convictions right now? Once you get that felony conviction, it closes so many doors. It's disgusting. It's sick. As far as I can see now, I don't think you have a felony conviction. And I hope and I pray that you do everything in your power to avoid a felony conviction, because I'm telling you, no one hires felons. If you ever want a good job, you want to get a loan for a car, hell, they're not going to give it to you. You want to get an apartment? They don't give apartments to felons, man. Does he have a felony conviction? You need to do everything in your power to avoid it. Go to WIMAC, do your shisa, get out, and show that you care, because what I see there, you don't care. And if you don't care, they're just going to send your ass to state jail with the felony conviction, and then it's done. Don't become a statistic. We're going to reset this case tomorrow because they want to talk to the complaining witness in this case. We're going to try to resolve this so that you can work on and go get on to WIMAC to better yourself. If you ever need anything, just talk to her, come back here. We can give you whatever you want. If you want a cell phone, you want a tablet, you want a place to stay, eat, money, we'll get it for you. But don't run the streets, because you're going to end up dead or with a 25-year sentence. Stop. Grow up. So we'll put them on for tomorrow. Come back, write it up, and we'll get it done.
All right, maybe.
Don't become a felon. All right.
Come back to United Mission.
Yes, ma'am.
Judge, let's first talk about Mr. Guzman in custody.
Okay.
That one got re-signed. I made a request for him to turn down the new case and all it popped up for vote.
In terms of subbing in for me or something?
I thought they were gonna give it to you, but they just made it to me.
All of them?
On this one, I think I was
It
on,
was an MAJ.
right, but I've been on it for like 2 or 3 settings. So am I out? Do I need to do a sub or something? I mean,
It was a deferred, it was a deferred information.
So no, you don't have to stop.
Easy money.
well, we're trying to, fixing to. I just need to talk to it. So should I talk about it or not? No, don't talk about it? Okay, and
One less.
okay. In that case, moving on, young Mr. Quaylar here, Judge. He's got a WI, first time, no priors. The situation is he missed court last time because he moved back to Victoria. He lives.
The Cuellar does what Mr. Cuellar wants to do without regard to court orders.
It looks that way, Judge, but he's been in good communication with me. I've talked to the family. His grandparents adopted him. He was actually in Houston to visit his biological father recently, and that's when this incident happened. And since then, he's actually moved back. His aunt is here. He's got family support. But I've talked to the family at length, and I've talked to him. Chief is okay with us, having a time served deal. We want to get it done today so he can move back. He's enrolled in school. He understands the severity of having this conviction, but he's got family. They have a business. He's going to be going to school and working there.
Who's here with him?
Well, I think they stepped outside, but his aunt and I think your grandfather is here. You want me to go get him real quick?
Please.
Jack?
Good morning, Ms. Okori. Ma'am, you're charged with assault causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am. Okay.
On March 5th, 2025, the officer was dispatched to a residence regarding a disturbance. The officer made contact with the complainant, who stated the defendant had assaulted him. The complainant stated they were involved in a verbal disturbance when she approached him, used a ring-style taser to tase him, and the complainant was able to knock the taser out of the defendant's hand and backed away. The complainant stated the defendant gathered the taser and approached him again at his front door, attempting to use the taser on him again. The complainant held the defendant's wrist to prevent her from touching him with the taser, and the complainant advised that he had to push the defendant to get her away from him so he could get inside the residence. The officer viewed the complainant's video footage of the offense, and the complainant stated he felt pain from the incident, was in fear for his life because he believed that she had a knife. The defendant stated the complainant struck her first, which was shown to be false with the video footage, and the defendant admitted to having a taser and using it on the complainant.
Okay. Ms. Okori, I'm going to find.
The taser never touched.
Stop. Now's not the time to fight your case. This is just a probable cause. Anything you say, they can use it against you. Now's not the time. I can give you a lawyer if you'd like. You can talk to the lawyer and go that route, but just now's not the time. You start saying stuff, they're just going to use it to prove your guilt. As it stands, I'm ordering you, ma'am, as a condition of your bond, not to have any contact with this person. I'm also ordering you not to be in possession of weapons. If you violate these conditions, I will revoke your bond, put you in jail. No more PR bonds. Do you understand, ma'am?
Yes, sir.
Was this a dating relationship or was this just a...
No indication of dating relationship.
Okay. So ma'am, would you like to apply for a court-appointed lawyer?
Yes.
Okay. Deputy Etchegone is going to give you an application I need you to fill out for me. I need to know everything about you. I will take a look at it. We're going to craft bond conditions for you. Do not leave until you sign our bond conditions, okay?
Okay.
Please.
I'm approaching off docket this morning, Your Honor, for Jermaine Mallett. I'm going to approach regarding the bond conditions. From my understanding, 2 of his conditions were that he could not drive, and the second one was that he has random drug test and a scram. So I wanted to see if we could get the provision regarding non-driving, see if we could get that removed. He does work. He works Monday through Saturday. He has a wife and
There's a reason why we do it though, right? Either they don't have a license, something is there. There's a reason why we have it on, right? And I don't know. Alex, tell me about the case, will you?
So in this case, the officer is dispatched to a motor vehicle stopped on the road with the male in the driver's seat passed out. The officer observed the vehicle stopped on the road facing the wrong side and forcing multiple vehicles to drive around. And the officer observed the motor vehicle's engine on and the defendant sitting in the driver's seat, appearing to be sleeping and passed out. And the officer observed an open container of Bacardi rum, 750 milliliters bottle.
Yeah. He's got to open up, you know? So I need show me proactive that you appreciate, you know, it's been 3 days though. That's not enough time. You know, some kind of proactivity that he appreciates, you know?
Yes, sir. He did let me know that he plans to start AA meetings with Veteran Affairs. I'm working on getting the documentation for that, but he did let me know that he plans to start that as well. So just come back.
Just be creative and then I'm all ears.
Yes, sir. Thank you.
Yes, ma'am.
I'm sorry, could we address the second thing or should I just come back all at once? The random drug test and scram, does he actually need both?
Yeah, but so we know he's not using illegal substances.
Yes, sir.
So the device only checks for alcohol, not for anything else. So that's why we have the randoms.
Thank you, Your Honor.
Okay, Arevalo judge, this is, he's in custody. This is one of these unlawful carry of a weapon where they're charged for being under 21.
This is the hard, unavoidable calculus in every plea-laden DWI courtroom. The immediate ease of a plea versus a lifetime of costs and collateral consequences. When the judge spells out, you give up the right to trial, the right to confront witnesses, possible immigration consequences, loss of appeal, and a record for life. They aren't scolding. They're clarifying the bargaining chips on the table. Accepting a reduced charge or education class now may avoid jail, but it often still leaves a permanent mark that will affect insurance, licensing, employment, housing, and even future jury credibility. Conversely, diversion programs or PTI can remove a case from a record if the defendant stays clean and completes the program. But those programs come with conditions that are not trivial. Monitoring, testing, fees, and logistical burdens that many indigent defendants can't meet without support. Judges often push rehabilitation because a conviction with no supports rarely reduces recidivism. Yet they also impose enough immediate pain or supervision to communicate the seriousness of the risk. For viewers, ask yourself, if you were advising policy, would you invest in making diversion accessible? Fee waivers, transportation support, employer protections, or prioritize automatic harsher sanctions that teach a lesson, even if they wreck someone's long-term prospects, which actually keeps roads safer.
Is that the only thing?
Yes, Judge.
Let's do PC then.
On December 20th, 2024, an officer responded to a residence regarding a shooting that just occurred. The officer stated over the radio that a concerned citizen pointed out a motor vehicle involved in a possible shooting. The officer followed the motor vehicle and began calling out in the direction of the motor vehicle. A felony stop was conducted. The defendant, 17 years old, was in possession of a handgun with a sling.
With a what?
With a sling?
I think they mean like a holster, Judge. Like a detective style holster, maybe.
Really?
That's kind of what I think of when I hear sling.
I'm Googling it now. A sling is like you hold it over.
Oh, the strap? Oh, okay.
But they charged, he's got an ag assault, an ag rob, evading in a motor. Oh, that's different. Okay, I thought it was because if it's all the same criminality, then that's something, but.
It's the first one he's charged, still in custody on the others.
So the only reason, because under 21?
Yeah.
Okay, I'm going to find a problem.
Okay, thank you, Judge.
For sure. ¿Llamaste a tu abogado?
Sí.
¿Qué está pasando?
Dice que ya venía, dijo, pero no venía.
It's Espinoza. I just can't get the lawyer. Do you know who it's? Garza's office, but we haven't had anyone come. So voy a poner tu caso para el lunes. Tienes que llamarlo para ver a dónde están. Tiene que llegar aquí Si no, vamos a tener una audiencia contra ellos, contra los abogados, ¿ok?
What about the box? Judge, what were the original bond conditions?
No
He's
alcohol.
done with me. Yeah. And how long, same for
How old is the case again? You got the docket, I don't even know.
133 days
It's
old.
just a normal reset, whatever John wants.
So if we're doing, a drug test, so we bring them back? for
No,
the-
no, we'll just do a normal drug test in hopes and praise and to everyone, Allah, God, just everyone, that it's negative. If not, then
So 30 days and then pending results.
Jesus, everyone.
Yeah, it is.
Shiva,
Okay. So 30 days brings you out.
Sibalinga.
April 15th or the 17th.
How about the 16th?
Required appearance for the results if they're positive.
Yeah, I think he might have just left to go do that though. Can I sign for him? You need to get that all?
Yeah, we'll just generate it. Did I say a little more? Okay, John, go ahead.
Yeah,
Yeah, thanks.
sure. Take care. Thanks, Jeff. Thanks for
Coming back, John.
Could have held her in contempt. Put her in the back.
She'll be on probation.
Yeah. Take care.
Still no Garza, so we'll roll it Monday. Vamos a posponerlo hasta el lunes. Llámate a tu abogado, por favor. Ok, por favor. No. Tienes que firmar. Hey, Brent. What's up, man? Go to it. We're done.